Hey everybody, Mr. Moffin coming back at you with another APGov video. This is our second video focusing in on topic 3.12, taking a look at balancing minority and majority rights. And this time we're going to be taking a look at some challenges in terms of trying to achieve, this idea of balancing rights between whites and ethnic minorities with regards to what happens in our elections. Now, we know that the Voting Rights Act is going to be passed into law in 1965, which is going to be a monumental piece of legislation that is going to bar the use of literacy tests. It's also going to be implementing, if you remember, a rule for those states that had been part of the Jim Crow South, that had a tradition of, in reality, denying people of color the right to vote. It stipulated that those states that when they did wish to change their voter laws and their election laws, and remember, voting laws, those are a state power, basically, that these former Jim Crow Southern states would have to get permission from the federal government, specifically the Justice Department, if they did want to change any kind of voting laws, because basically the federal government didn't trust Jim Crow Southern states to make changes on their own without fear of racial discrimination. Now, this is going to be, once again, a very important step in the idea of having more opportunity to vote regardless of skin color. But there's still some other challenges and concerns that go along with that. The idea being is, okay, now we're getting rid of the obstacles that kept people of color from voting, which is great, which is important, but what do you do to overcome the legacy of what was discriminatory voting rules, particularly in the South? In other words, you still have districts that have been drawn up in a way that have been designed to aid white majorities. So, how do you create opportunities for representation for people of color in Congress, given the legacy of racial discrimination? Well, you may recall that we talked earlier this year about the attempt by the state of North Carolina to create a minority-majority district to appease the Justice Department in the 1990s. But we found, as we mentioned in the case of Shaw versus Reno, which is, once again, a required court case for this course, that you cannot create congressional districts in an attempt to achieve some type of a racial majority. That to do so in and of itself is a violation of the 14th Amendment. So in other words, just like you cannot create congressional districts to specifically favor white people at the expense of people of color, you cannot do the reverse. So that is an important, ruling in terms of, how far, the government can actually go to make these changes in terms of representation in Congress. Now, the Voting Rights Act is going to also be affected about 50 years later. Just within the last 10 years, we saw a major shift in the power of the federal government with regards to voting from the Voting Rights Act. The provision that I just mentioned a moment ago that required former Jim Crow Southern states to get approval from the federal government to make any kind of changes to voting laws, that's going to be found unconstitutional. It's going to be stricken down by the Supreme Court in 2014. The court's argument is, or the court's ruling or opinion is going to be that we had come 50 years since the days of Jim Crow. And in that time, states have done now granted, this is an opinion of the court, that the states in question had done a much better job of making sure that opportunity exists regardless of skin color, and that there was not any real concern that literacy tests would be returning, for example, given how much has changed in terms of race relations in the previous 50 years. And so the idea being is that if the primary concern that necessitated the need of these southern states to get Justice Department approval to be able to make these voting law changes is gone, well, then the federal government is just controlling state powers regarding voting for an arbitrary purpose at that point. And remember, voting laws are a state power. It's a 10th Amendment thing. The Constitution does not give the federal government express permission to create voting rules, and it's not denied to the states, therefore it's a state power. So note, from a, kind of a strict interpretation standpoint, strict construction standpoint, parts of the Voting Rights Act needed to be stricken down to give states their authority via the 10th Amendment. But it has come with some consequences. We have seen in some of these southern states, once they've gotten the ability to have freedom to rewrite their voting laws, we have seen in some of these states a reduction in polling locations and shortening of voting hours, particularly on weekends and things like that, in urban counties and communities that tend to have above average African American populations, or populations that are of color. Now, note, we'll talk more about this in terms of voting habits, but we know that generally speaking, the majority, it's a slight majority, but a majority of white Americans do identify as conservative and vote Republican. A much larger percentage of ethnic minorities, be it African Americans, Asian Americans, Latinos, etc., tend to vote at a much higher rates for the Democratic Party. And so, there are concerns that, are these decisions made in the name of preventing voter fraud? Are these decisions that are made in an attempt to give, for example, maybe Republicans an advantage over Democrats that is just purely political? Or is it based on, racial, discrimination? And so, these are some very important questions, moving forward with regards to that. And hand in hand also goes, concerns and questions about recent voter ID laws. Now, voter ID laws have become a lot more popular in the United States over the last 10, 12 years. And the rationale for these voter ID laws is to crack down on any possible voter fraud that may be existing. And the idea being is that if you require, for example, a photo ID to be able to vote on election day. Now, note, these are rules that go above and beyond just the rules that are required to be registered to vote. So in other words, you might be legally registered to vote, but you would still be required on election day to show up with a photo ID before you'd actually be able to legally get that ballot. Now, concerns about this in terms as it applies to matters of racial equity have been found with regards to this. For example, let me show you this table right here, put together from a research research paper done by I want to give her credit here, by Vanessa Perez, who is from Columbia University, and she did research on the breakdown in terms of various aspects of demographics, age, income, but also ethnicity, with regards to the percentage of that population that owned or carried photo ID. And if you take a look here, now note this is data from about 7-8 years ago, so it's slightly dated, but I'm going to figure it hasn't changed that much since. You can see that there are some noticeable disparities. Yes, overwhelmingly, regardless of ethnicity, people do carry photo ID. Adult Americans carry photo ID. But you can see that there are noticeable differences based on ethnicity. As you can see here from this study, 95% of white Americans confirmed owning photo ID, whereas only 90% of Hispanics and only 87% of African Americans being able to say the same. Now, that might not seem like a big difference in the whole scheme of things, but when you were applying these percentages to thousands of votes in a city, or millions of votes in a state, or tens of millions of votes nationally, this can significantly have an impact. Now, once again, the purpose of what we're talking about here is not necessarily the motivations for these kinds of rules in terms of, questioning whether it is, purely for the idea of protecting against voter fraud. Even if that is the case, there are noticeable effects. The idea being is that if you know that you are creating policies in the name of preventing voter fraud that still tend to disenfranchise people of color, given that we know that these populations tend to have less photo IDs, is this creating more problems in terms of disenfranchisement than solving problems of potential voter fraud? We know that we have seen in the last 10 years that there are more people that are turned away from voting due to things like not being able to produce photo ID than actual sustained, proven examples of voter fraud across the country. So it does beg some concerns in terms of is the solution more problematic than any perceived problems that may have existed beforehand. So understand that even though we have the Voting Rights Act and it's been secured for almost 60 years now, there's still questions about making sure that there is not just access but real equity in opportunity in terms of representation and being able to engage in the electoral process. So we'll leave it there for right now, and we'll see you next time. Bye-bye.